case of Gessner versus Southern Company and Gulf Power, 23-2297. Are the parties ready to proceed?
Yes, Your Honor.
All right, may it please the court? My name is Ashley Richardson. I represent the appellant, Mr. Gessner, in this case, and I'd like to reserve 5 minutes for rebuttal.
Noted.
Thank you. So the basics on this case stem from the trial court dismissing, or I guess granting summary judgment on Mr. Gessner's private sector whistleblower claim. While there are additional factual holdings related to joint employer relationships, the big issue in this case is the sort of ongoing debate statewide and somewhat federally between the decision in Erie and the decision in Kearns, which was largely dicta, that dictates what actually constitutes protected activity under the Private Sector Whistleblower Act, unlike its public sector counterpart. And here, the court followed the dicta in Kearns, finding that in order to qualify as protected activity, Mr. Gessner must have reported something that was an actual violation of law, as opposed to other retaliation statutes and provisions which require only a good faith, reasonable belief that the employer or an employee engaged in some sort of illegal conduct. So currently, Erie is the overriding guiding precedent in the state. Many federal courts have followed it, some of which have said that because it is the precedent, that is why they have followed it. Others have expanded that it follows the Supreme Court's dictate to liberally construe all of the remedial statutes related to employment litigation. So our position is that there are 3 good reasons why Erie should remain the sort of precedent and be the precedent in the first DCA as well, as opposed to the dicta in Kearns. The first being what I just said, which is the liberal construction of these statutes. They're designed to protect employee rights, and limiting the application to just actual violations of laws kind of is counterintuitive and goes against that mandate to liberally construe those statutes. The second is that retaliation claims largely track federal law, which is derived for the most part from Title VII. And state law, Chapter 760, whistleblower claims, they all follow the same sort of shape and situation of a federal claim. The prima facie cases are the same, and for most other retaliation claims brought either under Title VII, the ADA, ADEA, Chapter 760, even the public sector whistleblower claims, the requirement is that the employee need only establish that they had an objectively reasonable, good faith belief that what they reported was a violation of some law, rule, or regulation. This would be the outlier, and it makes little sense when we look.
Some law, rule, or regulation, or a law, rule, or regulation. Doesn't have to be some specificity as to what they think the violation is?
Right, 448-101 defines what law, rule, or regulation is, and that it needs to be something that's legislatively enacted. There's a couple of guidelines. So we're not.
But just not a good faith basis. I think it violates something. I just don't know what it is.
Right.
As opposed to maybe it ends up not being a violation, but I'm pretty sure that this violates. Cite the statute.
Absolutely, and that's the good faith component. You can't avoid, let's say, a termination for poor workplace behavior by simply throwing out, I think that conduct was illegal. And the facts of this case actually lend really well to that analysis, as they were largely safety concerns or workplace safety issues, some of which would have been guided by OSHA and other applicable regulations to the type of work that Mr. Gessner was doing.
And is referencing OSHA generally enough, or does there need to be some specific provision of OSHA or a regulation adopted pursuant to OSHA?
I would argue that when we get to the litigation stage, it may need to be more specific, but we haven't found anything that says that the employee needs to pull out their legal books and walk into their employer's office and say, this is a violation of this very specific subsection of OSHA in order to gain that sort of protection. And like I said, the facts of this case where Mr. Gessner is, witnessing certain things, fires, blowing back in employees' faces and things like that, his experience, other employees' experience is saying, hey, this looks unsafe, it's probably against a regulation, or they've been trained on certain safety procedures, so that's going to establish that good faith.
Well, that's at that moment in time when he's reporting it, but now, it is in litigation, and there is a summary judgment motion, so what evidence was Mr. Gessner going to present as part of his case to show which law, rule, or regulation
Well,
actually, that he thought was violated.
Below, we cite it, and in the reply brief, I believe it was 29 USC 654A sub 1, which was just that OSHA requires that employers provide their employees with a safe and hazard-free workplace.
Well, and I guess that's where I'm going. So, I mean, that is general enough to cover any workplace safety. So if an employee reports some safety issue and that's a tripping hazard, I think it's going to be unsafe. That counts, and if he gets terminated for bringing it up.
I mean, I would argue that yes, if it's described in a statute, rule, regulation, something that's governed by the definition in 448, that's going to qualify. From what I've seen in my research, there's no bright line as to what qualifies as essentially a good enough safety violation or rule violation, law violation that would actually get you the good faith reasonable belief. I think it needs to be that the facts in each case would establish whether or not the employee actually had a good faith reasonable belief. There's a number of cases recently talking about retaliation claims and the theory that an employee might be like on thin ice. They've already had some kind of infraction at work or whatnot. If that employee then comes back and just says, safety violations, I'm now a protected whistleblower, you're getting into that factual analysis of whether or not that belief and what they've reported was actually made in good faith. The standards of objectivity apply. There's a lot of, I would say, protections for the employer in that regard. Whereas if we shrink the definition of what's going to qualify as protected activity to an actual violation, we're putting an undue burden on the employee to play lawyer, essentially, and come up with, hey, I've seen this, it's an issue, I need to report it, hold on, let me go check and see what exactly the statute is that I think that was violated.
What about if the employer has concern that's just a crazy employee that's reporting things that they clearly know are not violations, but he says that they are? They have no recourse on that? They have to go to trial everything?
Well, no, I think that would be a case on summary judgment of evidence of good faith.
How do you show good faith versus not good faith?
Well, I think a lot of it's going to have to do with the nature of what was reported. For example, if you have your crazy employee who's just decided that having all the blue pens on the table is a serious safety violation and the red pens are safer, I think we can dispense with that as just being sort of crackpot. Whereas, like here in Mr. Gessner's case, he's reporting very serious issues that could impact life and safety, and he's doing it repetitively, making the sort of same, not just throwing out accusations, but he's got other people that have seen, similar issues. I think that actually lends itself to his overall good faith.
Is every unsafe condition in the workplace an OSHA violation?
I'm honestly not qualified to determine that. I would argue.
What would you present at trial on that?
Well,
it seems like a fair question that you'd have to prove.
No, that I agree with, and I think what Mr. Gessner reported here, safety concerns on this, rather, I wouldn't say concerning job site, of them at a loss for the word, but one where safety is of paramount importance in the field that he was working in, reporting safety concerns, and OSHA has a number of regulations that regulate this particular industry and the type of plant that he was working in. So I think him, based on his training and experience, would be somebody who could sort of bring those issues to his employer as safety concerns. So again, going back to the text of Title VII, being sort of instructive here on the issue of whether or not the good faith standard or the actual violation standard should apply. Title VII in 42 USC 2000E-3A offers protection from retaliatory adverse actions to any employee who opposes any practice made an unlawful employment practice by this subchapter. So just based on that language, it's similar to the language we have here in 441.02.3, where it looks like you need to prove an actual violation. But that's actually not the case with Title VII cases where the good faith reasonable standard applies. Because the language is similar and because Florida cases are modeled after the federal cases in Title VII, it really lends to that analysis that this should be following the good faith reasonable standard. I know there has been some discussion in the briefing about the differences between the Public Sector Whistleblower Act and the Private Sector Whistleblower Act, specifically the obvious that under Chapter 112, the way subsection, it's 112.31875, the way the subsection is written, is that an employee is offered protection from whistleblower retaliation if they report an actual or suspected violation of law, rule, regulation, which has its own different set of definitions, of acts committed by other employees or agents or independent contractors. Whereas the Private Sector Whistleblower Act provides protection to those who report an a violation of law, rule, or regulation committed by the employer. So the methods of reporting are different between the two statutes. What is covered is different between the two statutes. And it seems that Title VII is more analogous to the actual drafting of Chapter 448-102, and thus would follow with the good faith reasonable belief. The third consideration is more of a policy consideration, and I mentioned it briefly, which is we're supposed to liberally construe these remedial statutes in favor of essentially aiding the employees in getting access to court and not really restricting their abilities to sort of redress wrongs in the workplace. If we put a stringent restriction like requiring that they establish that they reported an actual violation of law, we're basically expecting your basic employee to play lawyer, and that unduly burdensome on the employee, that they would have to see something that needs to be reported, report it, and then find out later that their good faith belief that what they saw was an actual violation of law, rule, or regulation wasn't, and now they've lost their employment in their case. The ramifications of that would be essentially a chilling effect on whistleblowing amongst employees. If you have to choose between, do I keep my job or do I play lawyer and hope that I'm right, we're going to essentially upend the whole purpose of the whistleblower statute, which was to protect employees who come forward with evidence or information showing that what their employer is doing is violative of some sort of law, rule, or regulation. So those are sort of the three.
Yeah, but if they're doing that, then they're identifying that it's actually a violation of some law, rule, or regulation. Right? Just what you're saying, then you won't have people coming forward to report things that are violations of law, rule, regulation. But if they are seeing things that they know are violations of law, rule, regulation, then they're going to report it because they know they're going to have protection.
The concern, though, is the knowledge. That's the tiny factor that's sort of the big elephant in the room on all of this one is, like, let's say, for example, in Mr. Gessner's case, he believed that what he was witnessing was a violation of OSHA regulations and reported it. And if the court were to later determine that that wasn't an actual specific violation of some OSHA regulation, he loses out. He's lost his employment and his livelihood because he thought he was doing the right thing. He had that good faith belief that what he was doing was essentially protecting the public and his fellow employees from serious safety concerns. If we take that away and force him to find the specific regulation and prove to his employer, like, you violated this law, rule, or regulation, I can't think of an employee who would risk their employment, particularly today, for that report.
Well, maybe they'd be more willing to risk their employment if they put in the work first and find out, okay, I know that I really believe this is a violation. I've looked up the regulations, and it looks like this is a serious problem. They're not just maintaining an unsafe workplace, but they're violating the law. Now that I have all my ducks in a row, I'm going to report this, and I know that I'm going to have protection if I do that.
I agree.
Isn't that how the law is supposed to work?
I agree with that to an extent, but there are two little caveats to it. The first one being an emergency or imminent nature of something. Like, let's say that we're on this job site and there's some kind of unsafe situation that's about to result in fire. Is the employee supposed to stop, go to the computer, Google OSHA regulations, try to interpret those OSHA regulations, and then run back to the supervisor and say, hey, this is a huge safety issue. You guys have to stop what you're doing. And the second being the running to Google and trying to play lawyer and sorting through all of these incredibly detailed, written by lawyers and politicians, rules that apply to their particular industry, and determining that they have gotten the exact correct portion of that statute or regulation or what have you, and that it applies. I mean, I've practiced for almost 20 years, and I can tell you that I have messed that up on my own, and I went to law school. So asking, the secretary at our front desk, for example, to sort through all of those regulations and determine for sure that she had found the exact statute that was violated before she makes her report, it undermines the whole point of the whistleblower statute, which is to ensure that employees are able to blow the whistle on unsafe, illegal workplace practices.
Well, that's what I mean, the point of the statute is to protect employees and encourage them to report illegal practices.
Correct, but if we look at the body of other remedial statutes that apply to employment law, none of them require the proof of an actual violation. For example, in a Title VII or Chapter 760 retaliation claim, the plaintiff isn't required to prove the underlying cause of discrimination. So we could have, a woman sitting at her desk surrounded by 3 other men, and she's decided that what she has witnessed is disparate treatment. They get to go to lunch, she gets punished for that. She reports it, but she doesn't know anything about Lewis or any of the other comparator standards that have come down recently. And as it turns out, each one of those men has a slightly different job than her. They have a slightly different supervisor. There's a different reporting structure. So they're not proper comparators. Her claim is technically not valid. But what she reported was a good faith belief based on all of her evidence that she had experienced discrimination, so her retaliation claim can still stand. The Kearns interpretation of this particular area of law would limit the Florida Private Sector Whistleblower Act to be like the sole outlier in that body of law, where good faith belief is applied to pretty much everything else, and this would be the one tiny portion where an actual violation was required, which, again, given that the whistleblower statute is designed to protect employees who blow the whistle on questionable practices, it seems to upend sort of the spirit of that. So if there are no other questions on that topic, I'm going to reserve what I have left for rebuttal.
May it please the court, Matthew Gutierrez on behalf of Applee Gulf Power. Your Honors, the Applees have agreed to split their time, with 15 minutes going to Gulf Power and the remaining 5 minutes going to Southern Company.
So noted.
The plaintiff in this case was terminated after he called his acting supervisor of Vietnamese descent an Asian sausage. And he called him this in front of his peers, and he prefaced this comment by noting that it was something that he should not say. But he said it anyway. And he said it when he was already on the highest level of discipline, following a long and documented history of conduct and performance issues that plagued nearly the entire decade of his employment with Gulf Power.
That's not why the judge granted summary judgment.
No, but it's an important context because it comes into play with causation and pretext. But it's important to reorient the facts at the outset, in my opinion, because it's really what we're here about. After Mr. Gester was terminated, shortly after calling his supervisor an Asian sausage, he filed this whistleblower action under section 448.1023. And the trial court entered summary judgment finding, as you've heard today, that an actual violation of law, rule, or regulation is required to be established, and that a good faith, reasonable belief is not sufficient. The appeal boils down to that simple question. It sounds almost as if they've abandoned the argument officially that an actual violation was occurred. Must a plaintiff establish an actual violation, or is a reasonable good faith belief sufficient? The second district analyzed the text of the statute and concluded that it requires an actual violation.
When you say actual violation, so in actual violation, like OSHA determined that it was a violation and there was a fine imposed or something like that, or just when looking at it, someone, maybe OSHA didn't find it was a violation, but if you look at the regulation and you look at the action or the thing that was happening, and someone could argue that it was a violation, is there a difference between the two? Like, do they have to show that it actually violated the statute, rule, regulation, and that some entity had determined that?
I don't think an entity has to determine it, but I think they have to prove it at summary judgment. They have to have evidence from which a fact finder could make the determination that an OSHA violation occurred. And in this case, they've fallen far short of that. And I'll get to that.
And there's sufficient discovery opportunity prior to?
They have not made any allegation or contention in this case that summary judgment was premature because discovery was still at its infancy. So, from my understanding, the discovery in this case was voluminous. There were numerous depositions taken, there were interrogatories served and responded to. So that's not before this court.
Yeah, I guess I'm still, I'm piggyback Judge Tannenbaum's question, and I'm not sure if you could speak a bit more about it. So how do you define actual?
An actual violation would be establishing that a law, rule, or regulation was violated. In the civil context, would be through a preponderance of the evidence, and the fact finder would have to ultimately determine that. I guess I'll jump ahead a little bit and just talk about the statute that they finally cite for the first time in their reply brief. They dedicate one line in their initial brief to arguing an actual violation occurred after listing a long list of things that Mr. Gessner says he reasonably believed constituted an actual violation. They dedicate one line on page 46 of the initial brief to say, well, many of these examples are also actual violations. And Mr. Gessner says of OSHA's safe workplace guidelines. He doesn't specify which of the examples are actual violations. He also doesn't specify which OSHA safe workplace guidelines he's talking about. For the first time in his reply brief, he cites 29 U.S.C. 654, which is referred to as OSHA's catch-all provision. This statute actually has 4 elements in the case law that a plaintiff must establish in order to establish a violation. You wouldn't find that in Mr. Gessner's brief because he doesn't spend any time whatsoever arguing that any of the elements were established. He appeals to common sense, and I think that his lead argument is really worth exploring because it shows the distinction between the actual violation and the reasonable good faith belief standard, and the implications of adopting one versus the other. So his lead argument is that hydrogen leaks on site constituted an actual violation of OSHA's safe workplace guidelines. He appeals to nothing more than common sense. He says because hydrogen is flammable, a hydrogen leak could have caused a fire or an explosion on site. Jason Clark, who is Gulf Power's site safety supervisor, testified that there is a permissible leak rate of hydrogen on site. He testified that there is no danger to employees as a result of a hydrogen leak unless 2 things occur. 1, the quantity of hydrogen is excessive, and 2, Gulf Power does not respond to the leak pursuant to their protocol. There is no evidence in this record from which a finder of fact could determine the quantity of any supposed hydrogen leak, and there's no evidence in this record that Gulf Power did not respond pursuant to its own protocols. To the contrary, Mr. Clark also testified that in response to a supposed hydrogen leak, OSHA went out to the plant, inspected the facility, determined that there was no violation, imposed no fine, and found that Gulf Power had responded appropriately to any supposed leak. So if we're traveling under perhaps the reasonable good faith standard, maybe Mr. Gessner's appeals to common sense, like hydrogen is flammable and therefore I'm in danger, might survive summary judgment for establishing protected activity, but they fall far short of the evidentiary showing that is required to show an actual violation. I'll go back now to the distinction, because I think it's important.
Can I ask a question? So you're in the brief that quoted the definition from the dictionary for is, so thank you for that.
Excuse me, I'm sorry?
It was your brief that gave us the definition of is from the
Yes.
from the dictionary, so
Yes, Your
thank
Honor.
you for that one. So you're focused on the text, but you're adding a word to the statute. The actual keeps getting repeated in this argument, and I'm curious why we have to have the adjective of actual in this argument, and why is it not enough just to talk about is it a violation? And did they present some evidence from which a reasonable juror could conclude that it was a violation?
Well,
Which is the past tense of the.
I think the word actual comes into play because of the case law, and there's a lot of debate whether airy or Kearns is correct. And so those cases have adopted the verbiage actual versus reasonable good faith, but the word is answers the question. Kearns paid attention to what the text of the statute says, and the words is in violation and the omission of any other words that qualify violation, like suspected or alleged, confirm that what is required is an actual violation. Something that is in violation is an actual violation. it's important, I would say, to understand where the reasonable good faith belief standard came from. In Erie, the 4th District cited to Luna. In Luna is the product of a long line of cases that has its origin in a case out of the 9th Circuit in 1978 called Sias. In Sias, which I can give you the citation, so Sias is 588 F2D 692. In Sias, the 9th Circuit was analyzing the opposition clause to Title VII, which, as my friend on the other side has explained, is somewhat similar to the statute in this case, in that it prevents an employer from retaliating against an employee who opposes conduct that is unlawful under Title VII. The 9th Circuit grappled with the same question that this court is asking itself. It said, is an actual violation required, or is a reasonable good faith belief sufficient? The 9th Circuit acknowledged that the words of Title VII would require an actual violation, but it didn't think it was fair. And I've heard a lot of policy arguments discussed in the briefing and in oral argument now about the merits of having a reasonable good faith versus an actual violation standard. The 9th Circuit said, we don't think it's fair that an employee's ultimate protection would hinge on the correctness of their belief. So even though the words of the statute would require an actual violation, we're going to create a policy-based, judge-made exception onto the unambiguous text of Title VII. And we're going to say that it is sufficient, even in the absence of an actual violation, that the employee had a reasonable good faith belief, and we're going to protect that kind of employee. Florida courts don't interpret statutes in this way. Florida courts follow the supremacy of text principle. The supremacy of text principle says that the words in a statute are of utmost importance, and what they convey in their context is what they mean. In this case, the words could not be more clear. Is in violation in the absence of any words like alleged or suspected qualifying the word violation show that an actual violation is required. This is made even more clear in the context of the provisions that surround it. Subsection 2, which is immediately above subsection 3, the legislature decided to protect employees who engage in whistleblowing activity that is alleged to be a violation. 2 provisions of the Public Sector Whistleblower Act do the same thing. The Public Whistleblower Act protects employees who engage in whistleblowing activity about a violation or a suspected violation. There is no such verbiage in subsection 3, which is the subsection that we're dealing with. So we submit that the 2nd District has it right and the trial court has it right, and that an actual violation is required.
What would be a piece of evidence that a plaintiff would need to present to hit that prima facie element to defeat summary judgment? Would they have to have an expert come in? And, if Mr. Clark's not going to give it up, bring in someone else from the outside, look at the whatever thing they're saying that they reported, and say, that in my experience is violation.
So
is that enough to beat summary judgment?
Mr. Clark testified that the manufacturer of the equipment has published the permissible leak rate. So first of all, you would need to establish what the permissible leak rate was and what the quantity of the leak was. The 4th element of establishing a violation under 29 USC 654 is feasibility, which we don't hear anything about. You'd have to have evidence that it was a feasible correction that would either eliminate or minimize that harm. We would also need evidence of that, both of which are lacking. So that's a concrete example of what is missing in their lead argument. And in fact, OSHA, again, went out, inspected, and determined that there was no violation of their lead argument.
What if, if we take you're describing an exposure type situation, so what if it can't be recreated? What if we don't know we can't quantify what the levels were because it's dissipated and it happened one time and then something that was done to fix it or mediate it? So how can you show an actual violation when you can't recreate the situation in order to even bring in an expert to testify? I'm guessing that the leak may have been, X amount, but I'm not sure.
There's evidence in this record of ways to figure out how much leaked. You can start from where what the quantity was within the system, and then you can finish with how much is left. And that's actually referenced numerous times. They just never bothered to figure out any particulars about any supposed leak. But there are ways to establish how much hydrogen was leaked from the systems based on the starting point of the amount of hydrogen in the system and what is left. If that makes sense. There are two other reasons, aside from the failure to establish protected activity, that the trial court did not rely upon, but which are other reasons why we should win in this case. First is causation. The plaintiff relies primarily on the temporal proximity between the alleged protected activity and the adverse employment action. The 11th Circuit has held that an intervening act of misconduct can sever any causal connection as a matter of law. In Hankins, which we cite in our brief, there was an only 20-day window between the protected activity and the adverse employment action. In between those two events, the employee publicly mouthed off to a coworker about an incident in the lunchroom. The 11th Circuit held that intervening act of misconduct severed any causal connection as a matter of law and upheld summary judgment on that basis. The last issue is pretext. So we have proffered our legitimate non-discriminatory reason for the termination, which was the Asian sausage comment. It was Mr. Gessner's burden to refute that. Mr. Gessner's own words, he said from day one, he was on a loud and consistent safety crusade. He was not fired on day one. He was not fired after year 1 or year 3 or year 5 or year 7 or year 8. He was fired shortly after he referred to his acting supervisor of Vietnamese descent as an Asian sausage. That is on its face a legitimate and non-discriminatory reason, and the case law says when an employer offers a reason like this, the employee cannot simply quarrel with the wisdom of that reason. It must meet it head on and it must refute it. It must show that it is false. Mr. Gessner has repeatedly admitted that he made this comment. Gulf Power is not required to tolerate that kind of language in its workplace.
You're into your time if you still want to split your argument.
That's all I have unless the panel has any further questions. We ask that the court affirm summary judgment. Thank you.
May it please the court, Russell Van Sickle on behalf of Southern Company. In addition to the reasons for upholding summary judgment that Gulf Power has argued today in both the Southern Company brief and Gulf Power brief, there was an additional reason that the trial judge granted summary judgment, particularly to my client, the Southern Company, and that was that the plaintiff did not meet its burden to show that the Southern Company was Mr. Gessner's employer. The plaintiff traveled on a joint employer argument. To have a joint employer relationship, two or more entities may contract with one another, and one of those entities retains enough control over the terms and conditions of an employee to be considered the employer. In this case, there is and was no such evidence. Southern Company is a gas and electric holding company in Atlanta. It owned at the time Gulf Power Company, which was located here in Florida. Southern Company doesn't actually have any employees. And Southern Company, most notably for this case, did not hire Mr. Gessner, did not supervise him, did not assign him work, did not assign him his work schedules, did not determine his pay, did not pay Mr. Gessner. Southern Company was not his employer, and therefore summary judgment was appropriate on that ground. The items mentioned by the appellant and the court below in the briefing is that there was a shared concerns hotline and a shared email convention of a name and then @southernco.com email address naming convention. Neither of those would make Southern Company an employer. But I do note, as noted in the brief, that in addition to the fact that just because there is a hotline doesn't mean that the operator of the hotline is your employer, but Southern Company, the defendant in this case, was not even the entity that operated the email or the hotline. That entity was a separate entity called Southern Company Services, Inc., which was not a defendant. So we would ask this court to uphold summary judgment to Southern for the additional reason that plaintiff did not establish that Southern Company was his employer for purposes of this statute. Thank you.
I will try to address these in the order they were presented. The first,
Can I actually do the last one first? How many employees does Southern Company have?
that I don't have an answer to that question.
Well, don't you have an obligation to submit some evidence, because employers actually define in terms of number of employees? That seems like something you should present as prima facie evidence to defeat summary judgment.
No, that I can, I mean, I understand the logic behind that. We, if, excuse me, if we look to, I think it's 29 CFR 825 106A, one of the ways to establish a joint employer relationship is to show that one employer acts directly or indirectly in the interests of the other employer, which is where we bring in the evidence about the hotline being operated by what Mr. Gessner believed
Sure,
was.
but at a minimum, don't they both have to be employers as defined by the statute?
I would, I
Before
mean,
you get to the question whether they're joint employers?
I think as long
The
as,
joint part, you have to get to the employer part first.
I don't know of anything suggesting that an actual physical number of employees is required so much as there is some kind of control or benefit between the two companies.
Except that the statute says it.
You're talking about the whistleblower statute?
Yeah.
The 10 employees, we would argue that the relationship between the two of them gets us the requisite number of employees, that they are acting on behalf of one another.
The argument is they didn't observe the corporate separation, the separate structures that they're actually engaged in. Was it fraud?
I wouldn't say fraud, I would say that there was, that the overlap between the two is where the joint employer relationship is coming from.
Okay.
But going back to the top, one of the issues that Gulf raised was that under Luna and the Ninth Circuit case, the name of which I did not get, although I did get the number, was that this sort of exception under Title VII was created in order to benefit the employees and follow the sort of liberal construction. And my colleague on the other side noted that Florida courts follow the supremacy of text, but what he failed to acknowledge was that Florida courts follow Title VII and federal law when it comes to interpreting these remedial employment statutes. And here, as I said earlier, Title VII more closely mirrors the language of 448-102 than any of its other counterparts, which would lend itself to that good faith belief. Moving into that, counsel also noted that Section 102.2 of the Private Sector Whistleblower Act does actually use the word alleged, but I think that the rest of that provision is really important to create a distinction, which is that in those instances, the employee at issue is given protection based on their participation in investigation. They're not necessarily the person who is doing any of the reporting. They have been called in by their employer to participate in this investigation. They may not even agree with the accusations that are being investigated by some third party or the company itself. They are simply a participant, and they are given protection based on that participation, not the contents of their report, just that they participated in that investigation. So I don't think that the two provisions and the use of the word alleged are analogous enough to force us into this actual violation standard, or the definition of the word is.
Well, let's just take, just for the sake of argument, let's take the good faith, let's take your position for a moment. What evidence is in the record that you presented to show that he acted in good faith in reporting a hydrogen leak being an actual OSHA violation?
Well, if we go with the hydrogen leak, the fact that the company sought to do something and OSHA came out to investigate whether or not there was actually a hydrogen leak that exceeded what these requirements would allow. If there was no good faith belief, then why would anybody choose to investigate? They would look at him like he's a crackpot.
Well, there might be something that is a good idea to address remedy and it not be a violation of a law, rule, regulation.
I think if Mr. Gessner, let's say for example, worked in the administration office and had nothing to do with hydrogen or the work being performed or any of the issues that may give rise to a safety situation, and he says, hey, I think there's a hydrogen leak, one could argue that that's going to be really difficult for him to establish that he had a good faith belief. He has no idea what he's talking about. He works in the office. But if we have somebody who's outside and says, hey, there's hydrogen leaking and it's flammable and that very much concerns me for my own safety and everybody else's safety, and then OSHA comes out to investigate that particular situation, I think it's provides that pretty substantial evidence that a reasonable jury could go, hey, he probably had a really good faith belief that that hydrogen leak was a situation because OSHA came out and reviewed it.
What about the intervening event argument?
Oh, under the pretext and causation. So as we put this in the reply brief, since it was brought up in the answer, that Mr. Gessner had this long history of engaging in these reports, and just a few days prior, he meets with his chain of command and outside counsel and then is immediately terminated. And we provided evidence that one, the comment was sort of that under the hostile work environment statutes was sort of that kind that doesn't really rise to the level of being offensive, and the person that it was directed at didn't actually find the comment offensive. And that essentially all of these other acts were really what the actual cause was. They've sort of slapped this thing together here at the end after he speaks with counsel about with his most recent safety concerns, and then he's immediately terminated on this accusation that he said something that was so offensive that he had to be immediately terminated.
Can we wrap up quickly?
I believe that I've covered everything that was in this set of notes, and we would ask that the court follow Erie and overturn summary judgment in this case.
Thank you. Thank you to both sides for your arguments. Court is adjourned.